On this episode of Off the Clock, Miller Johnson attorneys Sarah Willey and Rebecca Strauss continue part 2 of their discussion on terminations.
Okay, let's move on from separation agreements and talk about the termination letter. So oftentimes with severance and separation agreements, we do get consulted. We also sometimes get consulted with the termination letter, but probably not as often as we'd like, especially once we find ourselves in litigation, right? We find ourselves thinking, boy, I really wish I could have helped, right? Draft that a little bit better. So this is super in the weeds for people, but this is what, I mean, after you make a termination decision, you have to communicate it, right? So we're going to communicate it in 2 ways, right? One is verbally, and we're going to get to that, but then one is with the termination letter as well, okay? It's the belt and suspenders. It's not one or the other. Okay. Yes. Do you agree with that?
I do. With every once in a while, I have an exception, and I say, okay, you don't have to give this person a termination letter under very, very unique circumstances. But as a matter of course, I highly, highly recommend we, we're going to talk in a minute about the meeting, but we also provide something in writing. Yes. For that employee. And it doesn't just say we're ending your employment today, but it has where we started, which is the why we are ending your employment. And that's really for the same reasons we talked about at the beginning, which is when we leave a blank in that spot, right? When we don't say the why, that employee will fill in what they want. And if they don't, there's someone else in their life who probably will. Right. That person often leaves and goes home to someone else or has to tell somebody else that they're close to in their life, and that person may fill it in.
That's right.
And it could be a lawyer, by the way, right?
Yes.
And so I much prefer we fill in that blank.
Right. I do get the question several times a year, is it legally required that we tell someone?
Right.
The answer is no.
Nope. And we don't have to tell them in writing either.
But it is our opinion, we share this opinion, that it is best practice to tell people in writing and at the meeting, even if they are at will and you're not legally required to do it.
So with the letter, don't you agree there's a bit of a craft to it, though? How much to say, saying enough, but not too much.
Yes.
What is your preference?
So I have a few rules of thumb here. One is be candid and be honest. And that is easy to say, and people are like, well, duh, I learned that in kindergarten. But this is where I find organizations often struggle. And by the way, mostly out of kindness. Yeah. Not out of any bad intent. They think it's kinder to just say we're eliminating the position or to give no reason or, be very vague about it because they don't want to hurt the person. The reality is being involuntarily separated from your employment is a traumatic, hurtful moment, but people appreciate honesty and candor.
That's well put.
Yeah. Right? That is how you can take some of the sting out of it.
Being treated with respect.
It is being treated with respect and treating people as basically as you would want to be treated. And if you were in their place, and a lot of us have been, right? A lot of people watching have been, you would want to know the truth. Okay. So be candid, again, which sounds obvious, but we run into a lot of cases where that doesn't happen. And be fully candid. And by that, I mean, sometimes there's more than one reason. Include both, right? Literally, sometimes I've come across, there's just 2 things happening at the same time.
Sure.
So you list one and then you say, at the same time, comma, da-da-da. That's okay. But make sure both are equally, sufficient reasons for the termination. We do not want to pile on. That's at the other end of the spectrum, right? Every time this employee looked at you cross-eyed for the past 15 years, we're going to list that in the termination letter. That would not be appropriate. That does feel cruel and like piling on. But from a legal perspective, sometimes it's hard to remember we're lawyers, right? We do all the psychology and other things. From a legal perspective, if you list 15 reasons why someone was fired, and then you're challenged on that, you'll be held to account for each one of those 15 reasons independently. And if the former employee can prove that 2 or 3 maybe you were mistaken on or didn't really happen, or so-and-so here wasn't also terminated for doing this small thing, you might lose the case because of that. So be comprehensive, but limit it to the actual reasons for the termination, not just everything they've done wrong over the past
I've got a little
years.
trick. So the first thing I'll say is sometimes there's a specific event, there's misconduct that results in the decision. That's much easier.
Yeah.
Right. That's the easiest case scenario to write that letter. It's the situations in which there's been a continuing series of events or behavior, most often job performance, that have finally culminated in this decision. The trick I like to use is to say, for example, we're ending your employment because of continued job performance. We've worked with you and tried to help you improve. Unfortunately, this hasn't occurred. And then I like to say something like, some recent examples include a few things.
I love that.
Right? To send the message that we've got that objective reason and we've got the support for our decision, but not backing ourselves into a corner by saying, here's everything you've ever done that's not acceptable to us. Because that does feel both mean and legally problematic, right?
Both.
It doesn't win on either side.
Right. You want to be objective in that termination letter and not be emotional, right, when describing the reason, or really anywhere in the termination letter, right? This is, no matter what that person has done, they're still a human being.
Right.
Right. And the more we are humane with people in this very stressful moment for them, the better, frankly, risk management you will be engaging in. So, Sarah, let's transition from the letter to the conversation now. Why both a letter and termination?
Right.
Why both? What do you think?
Why an in-person meeting and a letter?
And the letter.
Yeah.
Yeah.
I think that's I think that brings in the humanity to it, right? To be able, I think it's important to show an individual the respect that you're willing to communicate with them. I used to say in person all the time, but more and more that's been difficult with remote workers, et cetera.
Right.
But at least look them in the eye and share the decision with them. I think sending them a termination letter in the mail without having that meeting sends a poor message.
That can be infuriating.
And a lack of respect.
Yeah.
And it can be infuriating. That's exactly right.
The flip side of that, what if I just meet with them? Do I also need a letter?
Yeah.
And to that, I think almost, again, with a few exceptions, but almost always yes. Because in the meeting, that is a very stressful moment. Not just we're focusing on the employer's point of view on this, but it's a very stressful moment for the employee. And they will remember very little of what you say, because when we're under high stress, our memories are actually very faulty. So they'll either remember very little or they will remember it incorrectly. They will think they remember it, but remember it incorrectly. So for that reason, you want to write everything down that you actually want the person to hear, right? So now let's talk about the meeting itself. And there's two big questions we get.
I think I know what they probably
about
are.
The meeting. Okay.
Right?
What are the two biggies here?
Who should be there from the company?
Yep.
Is the first one,
I've got
right?
that one a lot lately.
Both how many and who.
And who. And then the second big question is, that's been coming up more lately in the past few years.
Okay, so I have 2 in mind.
Oh.
2 second question.
I think that's a total of 3. I don't do math in public.
So the 2 other questions I would think of is the flip side of that. Can an employee bring somebody with them, which gets asked a lot. And then, but I think this is the one that you're referring to, is the recording question.
Yes.
What if this is somebody who has been recording conversations, or we think they've been recording conversations and we're pretty sure they're going to record this meeting? What should we do about that?
Yep.
And sometimes I'm now getting the question, even from the organization standpoint, can we record the meeting?
Yeah.
So, okay. So let's just start at the beginning. Who should be there on behalf of the organization? What's your view on that?
Okay. So first of all, there's no legal requirement that a direct supervisor, deliver the information. There's no legal requirement that HR be in the room. It's usually should the supervisor do it, or should HR, or should both, and then how many. Personally, I think the supervisor, the person involved in making the actual decision, should own it and be in the room. If they are very uncomfortable with having a speaking role, maybe another person, maybe they're one up,
right?
Or maybe someone from HR can actually have the speaking role. But I think it's very important, and frankly, the supervisor's own development, right, to see how these things go to help make good decisions. I also think it's respectful, to your point, to look someone in the eye and own it, right?
Yeah.
If you really believe this is the right decision, then we own it.
Yep.
I get this question a lot, but I don't actually have a strong preference for someone from HR being in the room or not, unless it's a high legal risk situation. What do you think?
Yeah, I agree.
I think it's a preference issue.
And it depends. Sometimes in different organizations, HR plays a different decision-making role.
Yeah.
I've seen situations in which HR approves or not the termination decision, in which case they really were an integral part of the decision. And my view would be they should probably be in the meeting.
Yep.
So
that makes sense.
I think it depends.
Right.
I do like the idea of two people from the organization being in the meeting. I think more than two is a little, to using your term, is piling on a bit, unless we can explain the reason why we need three people looking at the individual who's getting fired. I would tend to discourage having more than two.
I agree with that. But now let's talk about the other side. How many people can the employee bring with them? This is completely outside the union context.
Yeah, outside of the union context, in which case they've got a right to have a union rep present.
The answer is always 0, unless it's your culture, right, to allow some organizations that are not unionized still have a culture of allowing a support person or that sort of thing in stressful moments. I mean, that's fine. It's not that you have to reject that request from the employee, but you also don't have to grant it, right? If they want to some people want to bring a spouse or whatever it is, or a lawyer, we get that, right? When they know it's a termination meeting. The answer to that is always a hard no.
Is a hard no.
It's a hard no. Okay, so let's shift from that to the recording question.
Yeah.
Because, I mean, in the past, years since we all have recording devices in our pockets and our cell phones, that question has just exploded.
Well, and recording for Zoom meetings and Teams meetings too, it's so easy to record those meetings. Yes, the recording issue I have noticed a huge increase in that coming up.
Me too.
Not just in termination meetings, but in general. I will say that there's usually a very emotional response to the idea that somebody is recording conversations without us knowing it.
Yeah.
The first question I usually get is, "That's illegal, isn't it?"
They don't like it. Our clients do not like it.
Yes.
Yes.
And the answer is, it is not illegal so long as one person to the conversation knows it's being recorded.
At least in Michigan.
At least
Can
in
I steal
Michigan.
your thunder on
Yes.
the state by
Yes.
state? This is one area.
It is a state law issue.
Yes, that's a classic state law issue because the states are kind of split between two-party consent or one. Yeah.
Yes. And so, no, it's many organizations are surprised when I say, no, as long as one person to the conversation knows it's being recorded, it's not illegal.
Right. So that's when they find out about it after the fact.
Yes.
I agree.
Right.
They're usually very angry, but just to button that up before we go on to when the employee asks ahead of time, it almost always helps the employer. I have found.
Yes.
The recordings actually 100% of the situations I've been involved with help us.
Yeah.
Because it turns out you didn't make all these unlawful statements in the termination meeting, right?
Right.
Okay. So what happens when the employee asks, can I record this?
To record. So piggybacking on what you just said, right, I would encourage organizations to think about embracing that. Right?
That is going against the
That is
instinct.
going against everything we say. But the thing is you and I litigate. So we get into the weeds about factual disputes about what was said in meetings all the time.
Yep.
And that can be very problematic in litigation, right? So to me, the idea of actually having a recording, so there's no dispute about exactly what was said, is number one, could be really valuable. And to your point, actually helpful to the employer. Okay, so if we are willing to embrace the concept of a recording, then we should have one recording. We should agree that the recording is legitimate and transcribed correctly, and everybody should have access to that transcription, right? And I've worked through those steps with clients, and it's actually been actually quite nice. Again, in each case I've done that, it's been for an employee who's kind of known to be recording conversations, right? We've talked to clients about these employees. They say they're recording things, etc. And so we just say, look, you seem to think it's important to record conversations, so we're just going to record this meeting, and here's how it's going to go. We're going to record it. We're going to have it transcribed. We're going to send it to you, and you will have an opportunity to disagree with the transcription if you think it's not accurate. And if you do, then there will be a process to address that. But otherwise, we're just going to have a transcription of exactly what was said at the meeting, and both you and us will have access to that.
Perfect.
That eliminates the problem of maybe an individual having a recording and then having the ability to change or edit the recording in a way that's beneficial to them.
Right.
That's what we don't want.
And if we think it might be recorded, or even if it's not going to be recorded, how do we go into these meetings anyway? This brings me to my next point. You're going to want to prepare. You're going to have bullet points of talking points, not a script, but bullet points. And it should basically follow exactly the termination letter, right? We're here to tell you that your employment with such and such company is going to end either today or next week, blah, blah. Here are the reasons. Here's how to move forward, right, with benefits, COBRA, et cetera. So with that in place and prepared, there's really nothing to worry about in the termination meeting. So what if you're recorded saying those things? What is there to be embarrassed about? I think people do worry, whether they're being recorded or not, about if they meet with the person and give the reason, that the person will argue with the
That's
reason.
what I was going to say.
They'll challenge it.
Yes.
They'll say you're wrong, right? Or I didn't violate this, or I didn't do that. In my experience, it happens less often than people think it will happen, number one. Number two, allowing the person to tell you what they think of your decision face-to-face, eye-to-eye, is both humane, but also reduces the risk that that person will then go to a lawyer and sue you about it, right? They've had their say, they had their confrontation moment, they know you heard them, which is often what litigation is about. And so that can be a very good risk management strategy.
Yeah, that's
and
interesting.
Every once in a blue moon, someone says something that you kind of wish you had known before you finalize the decision. Right. Now, hopefully you did a good job in the decision-making process, but every once in a while, we're human, right? And so if someone does say something that makes you second guess the decision, it's totally fine to say, you know what, that's new information for me. You're still not going to be working here, right? But we'll make it an administrative leave for the next day or two until we, are able to follow up on such and such. Probably won't change the decision, so I don't want to get your hopes up. But that is an interesting point, and we're going to follow up on it.
Right. I really like that, and however, I would make a distinction between how we're going to respond to employees who react out of fairness, right? Versus employees who react by providing factual information, right? So, and I just say that for our listeners so that they can sort of plan for each, right? If it's an emotional reaction of, I can't believe you're doing this, I've worked here for 10 years, this isn't fair, etc.
A mountain out of a molehill,
yes,
that sort of thing.
Exactly.
Right. No, you don't have to rethink it.
Exactly. Then I think still think through how you're going to respond to that, what the response is going to be, because it should be a respectable, a respectful response. But that's different than somebody bringing forward new factual information that we just didn't know about before we met with the person. Does that make sense?
Yes. And how do we respond respectfully when someone is angry in a termination meeting? I was just telling you before we started recording, I actually was in a bunch of client termination meetings, and I found language similar to, well, we don't see it that way, but I can see why you feel that way, is a nice way to handle that, right? You haven't given anything away. You haven't been apologetic for a solid employment decision, but those feelings are real to that person.
And that's psychology 101, right?
Yeah, so
you can't argue with somebody over their feelings.
Right.
So you can acknowledge. But acknowledge that they're feeling. That way you can even say, I know this is hard, right? I can understand why this is difficult for you. Acknowledge their feelings, but then move on and say that that doesn't change the decision we've made.
Okay, let's wrap this up by talking about how termination decisions are wrapped up. How do we get the person from the termination meeting to their car? Okay, how do we, I get this. This is, again, there's no legal here.
Well, it's a great question.
But it's a very practical problem.
Right, because people think through the meeting, right?
Yeah.
But not always then we've gotten through the meeting and then we realize, oh, well, we're not done yet.
And this is very case specific, right, depending on the employee. But if we don't think the employee is going to, kind of blow up on the way out or steal things, blah, blah, I like to ask the employee. I mean, again, that's a very hard moment. It's an embarrassing moment for the employee. So as, again, being humane, I like to say, how would you like to handle,
getting your
belongings? Do you want to go collect them now? Do you want to come back, maybe in an hour when everyone else is gone? Or do you want to meet me early in the morning, right? When there's not, how do you want to handle that? And then let them walk out without an escort, either you or security, right? Because that is very demeaning to be walked out. Now, there are some circumstances that require it, and I understand that. But most do not.
I would say my preference in general is to have the employee gather up and carry out their belongings outside of business hours. And that's simply because your other employees are watching.
Yeah.
And that is, even if that was that person's preference to get their belongings in that moment and walk out, to others that looks like a demeaning moment for them, right? Does that make sense?
Yes.
And I think it, I don't know. I have a hard time with that. I would prefer they come back and get their belongings after working hours and aren't carrying their box down the row of cubicles with everyone looking and going, holy, you know what?
Yeah.
Sarah just got fired.
Well, on that uplifting note, we normally like to have a lot of fun in these episodes. This one obviously was a very serious topic, but we do hope that it was helpful to people and provides a little more guidance and process the next time they're faced with a difficult termination decision. Okay, let's get back to work.
Until next time. Thanks, Rebecca.
Bye.